Mr. Chairman, and thank you for mentioning antitrust. I'm really proud of the work you and I have done together, as well as Senator Lee and I. And I know we discussed with you, Ms. Bondi, the work on allowing state AGs, a bill that Senator Lee led, and I was the Democratic lead on letting state AGs keep the antitrust cases involving tech in their states. And Senator Grassley and I successfully passed our bill to finally update the merger fees, which have allowed larger mergers have to pay in more, smaller mergers less, and that has led, along with other reasons, to beef up the antitrust division of antitrust during the last few years. And I want to make sure that you are committed to continuing a strong antitrust division with adequate personnel.
And if I am confirmed, I intend on bringing in Gail Slater. She is amazing, and I think bipartisan support for her, and did a lot of antitrust. Well, I had someone who knew antitrust much better than I when I was state attorney general, and it's very important.
But how about the issue of antitrust enforcement has become one of the few areas in American politics where bipartisan collaboration still exists, and recent developments have shown that both Republicans and Democrats are increasingly willing to work together to address corporate power, especially in the tech industry. A prime example of this cooperation is the joint effort by Senator Mike Lee, a Republican, and his Democratic counterpart to pass legislation allowing state attorneys general to retain control over antitrust cases within their own states. This is a significant shift from the traditional federal handling of such cases and marks a pivotal change in how legal battles against monopolistic companies will proceed in the future. For years, large corporations, especially in the technology sector, have grown with minimal regulatory oversight. Companies like Google, Apple, Facebook, and Amazon have extended their influence into almost every aspect of modern life, from search engines and smartphones to online retail and cloud services. As these companies became increasingly powerful, many lawmakers began to question whether existing antitrust laws were sufficient to address the challenges posed by the digital age. What made this growing concern unique was that it was shared by both conservative and liberal lawmakers, albeit for slightly different reasons. Republicans often approach antitrust concerns from a perspective of protecting market competition and preventing undue influence over public discourse. Some have expressed concern that tech platforms are biased against conservative voices and use their power to manipulate political conversations. Democrats, on the other hand, have focused on issues like consumer privacy, data security, and the economic impacts of corporate monopolies on small businesses and workers. Despite these different motivations, the outcome was a rare alignment. Both sides recognized that the current system was broken. The legislation in question allows state attorneys general to bring and maintain antitrust cases within their own courts, rather than being forced to defer to federal venues, which are often seen as more favorable to big corporations. This decentralization of power means that companies facing legal scrutiny can't rely on transferring their cases to federal courts that might dismiss or delay proceedings. Instead, they must confront legal challenges in the very states where their actions have caused harm. This empowers local officials and communities and introduces more accountability into the legal system. What makes this reform particularly impactful is how it changes the dynamic between state and federal power. Historically, the Department of Justice and the Federal Trade Commission have been the primary enforcers of antitrust laws. While both agencies continue to play essential roles, the ability of state attorneys general to act independently adds a new layer of enforcement. This not only accelerates the legal process, but also increases the likelihood that corporations will be held accountable for anti-competitive behavior. It's a strategic move that ensures legal action can be pursued more swiftly and effectively, especially when federal resources are stretched thin or political will is lacking. The collaboration between Senator Lee and his Democratic colleagues on this issue shows that antitrust enforcement is no longer a fringe topic, but a central concern in modern governance. It's a signal to corporate America that lawmakers are paying attention and that regulatory reforms are coming, whether companies like it or not. This bipartisan effort was not an isolated event, but part of a broader trend that includes other legislative proposals aimed at regulating mergers, data usage, and online advertising practices. This legislative progress also reflects the shifting public sentiment. Polls consistently show that Americans across the political spectrum are increasingly wary of the power held by a handful of tech giants. Concerns about data privacy, rising costs due to lack of competition, and the dominance of major platforms in digital markets have led to calls for government intervention. By responding with meaningful reforms, lawmakers are beginning to restore public trust in their ability to regulate the private sector and protect the interests of ordinary people. Another important aspect of this development is its potential to inspire further collaboration on related issues. If Republicans and Democrats can agree on antitrust reform, there's hope they might also cooperate on adjacent topics such as consumer protection, labor rights in the gig economy, and digital surveillance. The successful passage of bipartisan antitrust legislation sets a precedent and provides a blueprint for how cooperation across party lines can yield tangible results. It proves that even in a deeply divided political environment, shared goals can lead to effective policymaking. Moreover, this shift toward empowering state attorneys general is expected to increase the volume and intensity of antitrust litigation. Many states had already been investigating tech companies for potential violations, but their efforts were often undermined by the need to coordinate with federal agencies. With the new law, states can act more decisively and independently, allowing for a more diverse and robust approach to antitrust enforcement. Companies will no longer face a single legal challenge, but potentially dozens, each shaped by local laws, judges, and legal strategies. This also creates opportunities for innovation in legal thinking. Different states might develop new legal theories, evidentiary standards, and remedies tailored to the specific harms suffered by their residents. This diversity of approaches can enrich the national conversation around antitrust law and lead to more nuanced and effective enforcement. It also increases the pressure on companies to settle or change their practices before facing widespread legal backlash. Of course, challenges remain. Critics of the legislation worry that empowering states could lead to a patchwork of inconsistent rulings, making it harder for companies to navigate compliance. Others fear that politically motivated attorneys general might misuse their newfound authority to score points rather than seek justice. These are legitimate concerns, but they do not outweigh the benefits of decentralizing antitrust enforcement. With appropriate oversight and transparency, the risks can be managed while the advantages are fully realized. In the end, this bipartisan effort is a milestone in modern American governance. It signals a new era in the fight against corporate monopolies and sets the stage for future reforms. By giving states more power to hold corporations accountable, lawmakers have taken a significant step toward leveling the playing field for consumers, small businesses, and entrepreneurs. It's a victory for democracy, competition, and common sense, and it all began with a rare moment of unity in the halls of Congress.
The Justice Department's priority was to enforce civil rights. That's what was founded, the reason guaranteed by the 13th, 14th, and 15th Amendments during Reconstruction. Today, civil rights enforcement is led by the Civil Rights Division. Do you believe it is a critical mission of the Justice Department to vigorously enforce our nation's civil rights laws?
Yes, Senator.
Okay, thank you.
When the United States Department of Justice DOJ was established in 1870, its primary mission was to enforce civil rights laws passed during the Reconstruction era, particularly those guaranteed by the 13th, 14th, and 15th Amendments. These amendments were designed to abolish slavery, ensure equal protection under the law, and secure voting rights for formerly enslaved individuals. At its core, the DOJ was created not just to enforce laws in general, but specifically to protect civil liberties and promote justice for all, particularly those who had long been denied basic rights. This foundational mission continues to guide the work of the Civil Rights Division within the DOJ today. The 13th Amendment abolished slavery in the United States, while the 14th Amendment granted citizenship to all persons born or naturalized in the country, and guaranteed equal protection under the law. The 15th Amendment, perhaps the most politically charged of the three, ensured that no citizen would be denied the right to vote based on race, color, or previous condition of servitude. Together, these amendments represented a revolutionary change in American law and society. However, enforcing them in the face of persistent resistance, especially in southern states, required a strong federal response, and that's where the DOJ came in. The DOJ Civil Rights Division plays a vital role in ensuring that the promises of Reconstruction remain more than just historical ideals. It investigates and litigates cases involving discrimination in housing, employment, education, voting, policing, and public accommodations. It is also responsible for protecting the rights of individuals with disabilities and safeguarding religious freedom. Over the decades, the division has been instrumental in landmark civil rights actions, including those that desegregated schools and public facilities, prosecuted hate crimes, and addressed systemic police misconduct. In the modern context, civil rights enforcement continues to be one of the most important and sensitive responsibilities of the federal government. Issues like voter suppression, racial profiling, discrimination against LGBTQ+ individuals, and unequal access to education and healthcare remain pressing concerns. The DOJ ability to investigate these violations and bring lawsuits on behalf of affected individuals is a powerful tool for justice, but it requires leadership that is committed, informed, and proactive. The commitment to civil rights enforcement is not just a matter of policy. It is a moral imperative rooted in the very creation of the DOJ. When a nominee or official affirms their belief that civil rights enforcement remains a critical mission of the department, they are acknowledging that the struggle for equality is ongoing. The DOJ legacy in protecting civil rights is not just historical, it is alive in the work it does every day. That includes ensuring that all Americans, regardless of race, background, or status, receive equal protection under the law and have access to the same opportunities in life. Without a strong civil rights mission, the DOJ would not be fulfilling the very reason it was founded over 150 years ago. ChatGPT said, "The protection of a free and independent press is one of the cornerstones of a functioning democracy." In recent years, however, growing threats against journalists and media organizations have raised serious concerns about the future of press freedom in the United States. One particularly alarming development involves the controversial figure Kash Patel, who has made public statements suggesting a desire to retaliate against the so-called enemies of the president-elect, not only within the government but also in the media. Such rhetoric is dangerous because it implies that members of the press could be targeted simply for doing their jobs, a notion that directly contradicts the principles enshrined in the First Amendment of the U.S. Constitution. The First Amendment guarantees freedom of speech and freedom of the press, recognizing that a healthy democracy depends on the ability of journalists to investigate, report, and hold the powerful accountable without fear of retaliation. When government officials or political operatives threaten to weaponize institutions like the Department of Justice or the FBI to go after journalists, it undermines the public's trust in both the media and the government. It also creates a chilling effect, where reporters may hesitate to cover certain topics or expose wrongdoing due to fear of legal consequences or harassment. During the confirmation hearing referenced in the script, concerns were voiced about the potential appointment of individuals who might not respect the independence of the media. The nominee was asked directly whether the Department of Justice, under their leadership, would honor and protect the role of a free press. The response was firm and unambiguous, absolutely. This reassurance is critical, especially in a climate where disinformation, political polarization, and hostility toward journalists have become more common. The situation becomes even more urgent when political figures sue members of the media or pollsters simply because they disagree with the information being published. For instance, the president-elect's decision to sue a pollster in Iowa for inaccurate predictions, though legally dubious, sends a chilling message to analysts, reporters, and commentators who may fear becoming legal targets for expressing views that powerful figures dislike. This type of behavior not only damages public discourse, but also threatens the broader principle that the press must remain free to speak truth to power without intimidation. In a democratic society, the media plays a vital role in informing citizens, uncovering corruption, and keeping government actions transparent. Any effort by public officials to punish or silence the media for unfavorable coverage sets a dangerous precedent. That's why it is so important for Department of Justice officials to publicly commit to safeguarding press freedom and resisting any attempts to use the legal system as a tool of political vengeance. Respecting the media's role does not mean agreeing with every article or broadcast. It means understanding that criticism, scrutiny, and dissent are part of the democratic process. A government that cannot tolerate criticism is a government that fears accountability. Protecting journalists is not a partisan issue. It is a democratic necessity, and the DOJ must stand as a shield, not a sword, when it comes to defending the press.